But
Hi,
before,
everyone. Thank you for joining us this evening for a webinar about protecting your pets for life. My name is Pascal Hansen. I'm the founder, CEO, and financial strategist at Zeta. And I'm here with Raphael Tachie, our guest speaker, and my associate, Tanya. So Raphael's going to educate us about setting up a trust for pets. Then I'll speak very briefly about how to fund that trust. And then we'll end with a Q&A, and we're a small group, so I hope to get all your questions answered. If not, you can always contact either me or Raphael to talk about your particular situation. So, a little bit of background on Raphael. Like I said, he is, I believe, one of the best estate and tax lawyers in the country. He is a partner in the Trust, Estates, and Wealth Preservation Group at Dentons, based in Vancouver, and he works with clients across both Vancouver and Toronto. He advises high net worth individuals, families, entrepreneurs, and business owners on estate and trust planning, business succession, incapacity planning, and tax efficient wealth transfer strategies. Raphael also works closely with executors, trustees, financial institutions, and trust companies on estate administration and fiduciary matters. So he really knows what he's talking about when it comes to this. He is going to share with us how trust for pets work and how to structure them properly so that your wishes are legally enforceable and your pets are cared for as intended. So thanks again, Raphael, and over to you.
thanks, Pascal. Before I start, can folks see my slide, or I want to be sure that my slides you can see it
We're
before I
just
dig into it.
we're just seeing you.
Okay, let me see. Uh, Share. Yeah. Okay, I think it's sharing now.
It just says Raphael started screen sharing. Yeah, there we go. We can see it.
Okay, perfect. So, hi everyone. I lead our trust and estates practice, the solicitor side practice in Vancouver and in Toronto. And really, my I've been practicing for about it's getting close to 20 years, which is starting to show, I guess, because it's starting to be one of those where every time I say that number, it feels a little bit different. But I've been doing this work for a while, and what I wanted to do when I had a conversation with Pascal about estate planning where for pet owners, and you will notice that I'm not saying pet trust or trust for pets, and I'll explain why. But really, when you're doing estate planning for pet owners, you want to think about the relationship that we have with our animals and our animal family. And I'll start off by telling you a story that um, hopefully it doesn't have the reaction that it had when I first told it. Right after law school, I was interning at a law firm in Toronto, and there was about 40 students that came in that year to intern. And I joined the conversation late. It was a social event, and I joined in the conversation late. Everyone was talking about their relationship with animals, and I thought, you know what? Let me jump in. And if you're not seeing me, you probably by my accent can tell that I'm from somewhere else. I immigrated from Ghana, and in Ghana, my dad had a poultry farm. And at the beginning of each year, I'm one of three boys at a time, he'll give us all a little check that he had to raise and take care of for the year. And at the end of the year, your reward was that check would have grown to be a full-grown chicken, and we would have it for Christmas. And yours would be like your prize was like you get to pick whatever piece of the chicken you liked. So I told that story, and everyone that I told in that group looked horrified. And I thought, what happened? We're all talking about animals. I told my animal story and it just didn't go over, it didn't go over very well. And I realized that in that instance, there was a cultural gap around our relationship in Canada with our animal friends and my relationship at the time as not a new immigrant, but somebody that didn't know that cultural difference about people's relationship with their pets. And so I was telling a story that I thought fondly of, but realized in the moment that it was out of place. The reason why I tell you that story in the context of estate planning is that your view of your pet as a member of your family is very different than how the law in Canada looks at your pet. There is assumptions and cultural and societal assumptions built into your relationship with your pet family, your animal family member, that the law doesn't always recognize. And so if you're going to do estate planning and be intentional about how your pet is treated, you have to understand that piece because it will inform the nature of the plan you will put in place for your pet. So this presentation really comes out of that lens, and it's a really, hopefully, a plain language exploration of the difference between how we view our animal family members and how the law views them. And we will be able to come to a plan that gives us a bit of peace of mind as we deal with our animal family members. So what happens? This presentation will matter to you because we're going to talk about what happens to your pet if something happens to you. The guide that covers the BC legal landscape. I realized as Pascal was doing the introductions, I heard that a couple of people were from Alberta. This doesn't change very much if you're in Alberta. And so just know that some of the concepts we're talking about will still be applicable outside of BC, but my talk today is primarily focused on BC law. So I told you about really the big piece is in estate planning, there's a misalignment that exists on how we see our pets and how the law sees them, and we're going to talk about that. So this is what I asked our AI tool at the office to generate a photo for me about the story I just told you, and this is what came up. I thought it was interesting how I saw ch that little chick as a meal, and my friend saw that little chick as a pet, and how that misalignment had led to a really embarrassing moment for me at the time. Similarly, the law sees our animal family members as property. So we might see our little puppy, our dog as, a part of the family. The law does not do that. It sees them as similar to the furniture you own in your house, the car you own. It's a piece of property that you own. So when we talk about pet trust, usually people think about the famous celebrity pet trust cases that you've heard about. Michael Jackson apparently had a trust for Bubbles, his pet monkey, that is ongoing till today. Leona Hemsley had a pet trust for $12 million for her pet dog. That's the kind of cases you see, but if you listen closely, a lot of those cases come out of the US. In the US, the concept of a pet trust exists. And even in Germany, I believe there was a countess that created a trust for her dogs. Those are concepts that do not exist here because we do not see our pets as, I think, let me caveat that to say that I think the courts are starting to change on this, but generally, our law does not see our pets as part of the family, but rather as property. So the big difference between how you and your pet, how you view your pet and how the law views it. Many Canadians have strong bonds with their pet. 77% of Canadian households have at least one companion animal, and 28 million pets nationwide, at least as of 2024. We integrate our pets into our family life. That is how we, as Canadians, see our relationship with our animal companions. The legal piece, the law does not see that emotional connection. Legally, it's a pet's legal property. And increasingly, as I mentioned, I think the law will start to change to accommodate that, but that's not currently the case. The importance of estate planning is being proactive to ensure that the future care of your pets reflect your wishes, and that we deal with the misalignment that exists under the law for our relationship with our pets. So now let's look at the legal framework that exists. We've talked about a bit about why the misalignment. So pets, because they're not considered family members, cannot be beneficiaries of a will, right? They cannot be people that receive an inheritance under BC law and generally under Canadian law. A pet cannot receive an inheritance. What you must do is you must leave your pet and the care of funds that are meant to take care of your pet to a trusted person. So you have to have somebody in place that is going to have the primary responsibility for taking care of your pet and essentially step into your shoes as I'm going to use the word owner because that's kind of the closest thing I can come to as owner. And then you're going to leave funds for that owner to take care of the pet. It's slightly different than saying I'm leaving everything to Bubbles, like Michael Jackson might have done. Courts are starting to recognize pets as special, but not, and so we're treating pets slightly differently as different from furniture and cars, but we're not fully at the place where you can leave an inheritance directly to a pet. You need human helpers. You need a new owner. You need a new trustee. A trustee is a person that's going to be legally responsible for looking after any funds that you leave behind to take care of your pet. And you have to leave clear instructions on how you want that pet to be taken care of, both in your will and your power of attorney. And we'll talk about your power of attorney later. But just that's kind of the framework that we have to work through when we're considering how are we going to take care of, how are we going to provide for our pets when we're no longer here or when we're no longer capable of looking after them. So let me talk about, we are here to talk about pet trust, and I just told you you can't have pet trust. What does that mean? As I said, it's mostly a US creature, pet trust. BC does not allow that. You cannot have a non-human beneficiary of a trust. So your trust has to have a human at the end of it when you create a trust. In the US, you can also sometimes create what's called a non-charitable purpose trust. And even in Canada, you can do that, but it's limited to 21 years. And you can do that as the purpose is to take care of your pet, right? So I'm creating a non-charitable purpose trust and you'll see that I refer to what I call the pet fund, right? That is meant to take care of my pet, but that trust can only last for a certain amount of time. How that pet is that trust is enforced, it's uncertain because at law in BC, you need a human to enforce the trust. And if you don't have a human who's the ultimate beneficiary of a trust, it might be challenging to enforce it. So what does that mean? It means we need practical tools to deal with, to provide for our pets and our animal companions when we are no longer able to do so, either while we're alive or on our deaths. What happens if you don't have a plan? Your pet could be rehomed, it could be given away, it could be euthanized against your wishes. Your executor, you could leave your executor in a place where they have to figure out what to do with your pet during a stressful time when they're also managing your estate. And if they're a family member, they're also dealing with potentially your death. So you do not want to kind of leave people in that position where they are worried about your pet and they're trying to find a home for them while at the same time dealing with grief or dealing with having to manage your estate and your family and the grief that your family members are going through. You have no guarantee without a plan that your pets will end up with the person that you want to care for them. So I've just finished a plan where we wanted to make sure that certain horses went to a particular individual because they care about the horses. They're in the community of dressage that the horse is involved in. And it was important for the pet owner for us to identify the right person who would be part of that community and ensure that the horse was still part of that community on their death. So you want to think about who the right person is who's going to have to care for your pet. Some real life examples that I've worked on what folks have done. I've had a client direct annual payments from the estate to the pet for the care of the pet, including paying for vet visits, food, and other needs. The trade-off for that plan is that estate is going to exist for a little while longer than it should. Normally, most estates last up to a year, maybe a little past a year. But in this instance, this is going to last a little while longer because we want to make sure that pet's taken care of. But the big lesson in planning for pets is you're going to balance simplicity, cost, and control that you have over the plans. The more simple your plan is, the less control you're going to have. The more control you want with respect to how your pet is cared for, the more complex your plan is going to be. And I'll walk you through a few options, about 4 options that we will walk through today. Option 1, you can name a new owner for your pet. You can say, if something happens to me, I want my friend Pascal to be primary caregiver for my pet cat, and at least one alternate, and I can do that in my will. I can provide funds out of my estate to transport my pet from wherever I happen to be living with that pet to where the new caregiver might be. I want to make sure I talk to the new caregiver ahead of time so that they know they're expecting a new family member. They'll be receiving a new family member, and they might need to make room for that family member. And you want to give your trustee power to select a caregiver if the people you've named aren't available or can't do it. So not only do you want to name somebody and name an alternate, but you also, in addition to that, want to make sure that there's flexibility for your executor or your trustee to be able to name somebody if the people you've named are not able to handle your pet or take care of your pet for you. This plan is generally simple. It avoids any ongoing trust complexity because we haven't created a trust fund. We haven't created a fund to support the trust, to support the pet. We've just named somebody that's an alternate, and if we can, we've directed some funds to help pay for the cost of taking the pet to the new owner. Option 2, we can provide a cash gift to the caregiver. So not only are we going to name a new person that's going to be a caregiver or a new owner, but we're going to provide a cash gift out of our estate to that person. So we can leave a lump sum that says, hey, Pascal, on my death, I want you to take care of my pet cat for me. But if you agree to do so, I've asked my estate, my executor, to pay you $100,000 without interest to fund the care and food and life expenses of that pet for me. And so what you have done here is a cash gift. The gift isn't for the pet. The gift is to the caregiver, and with an instruction and a wish that they will take care of the pet. So here again, you want to talk to the person that you're naming because you're going to have to trust that they will spend the money the way that you're intending. You're not legally binding them, but rather it is a wish that you're expressing to them. Generally, if the pet dies before the caregiver has the money. The gift is a thank you and a contribution, right? It's not a whole trust with rules and things like that. It is, thank you for agreeing to do this. Here is money to support the care of the pet. Again, this is simple. There's no ongoing trust administration. It's like money goes along with the pet and then it's done. Third option, we can create a pet fund. Remember, I'm not calling a pet trust, with a trustee who has oversight. So what it is we set aside funds in our will and we name somebody to manage the funds for pet expenses, right? So it's going to be, hey, Pascal, I'd love it for you to be the caregiver of my pet. Raphael, I'm going to name you as a trustee of my pet fund. You can also name Pascal if you chose to, right? And your job is to pay for the vet bills, the food, the grooming, everything that a pet needs. The trustee manages the money that's set aside, right? And pay for expenses. And there's rules around what the money is supposed to be used for. The fund duration, the fund must end after the last pet dies, if there's multiple pets. 21 years passes after the date the trust is created, or the trustee decides to terminate it, ensuring controlled use, right? So this is it's essentially a trust, right? It's just that the trust is meant to fund the cost of the pet. And the remaining funds will go to people that you've named. Remember, the pet itself cannot be a beneficiary of the trust in terms of the end person to receive the funds. So we name people as a backup. If the funds are not finished when the pet dies or the trust is collapsed, there's people there to receive the funds. What are the benefits? You have more control, but notice you also have added complexity because you might have one or two people, one of whom is a caregiver for the pet, the other one of whom is managing the pets. Also managing the fund. Ongoing duties, you have to do tax reporting, you have to do administration, you have to invest the money. It's a lot more complicated. But it provides oversight and reassurance and involves that you have way more control over how the money is going to be used for the pet's benefit. But it definitely has a lot more work to be done around it. Let's talk about option 4. You can leave pets to a charitable organization. So if you have no family or friends that can take the pet, you may consider a not-for-profit that might take the pet. I'll give you an example of the Richmond Animal Protection Society in Richmond, where they operate sanctuaries and they have a vet hospital and a shelter and a foster program. Usually, when people leave their pets to these organizations, they'll also make a donation in support of animal welfare so that there's not only is the organization receiving the pet to care for it, but it's also receiving some funding to support its activities. The charitable organization will be the caregiver, and they can offer sanctuary for the pet. They can, if they're not the caregivers, they can minimum act as shelters and operate foster programs for animal welfare. What is the benefit? It provides assurance that there will be professional care and support, especially when there's no family or friends. And you can leave donations as part of the request, so that there is at least some financial support for your pet when it ends up with an organization like that. So everything we've talked about if you are not alive, you've died. But what if you are alive, but you cannot take care of the pet anymore because you've aged, you're hurt, or you're mentally incapable? You can provide, as part of your power of attorney for your own incapacity planning, you can provide for your pets. So I'm alive, but for some reason I can't manage my own finances and I need help. I need help from someone to manage it, but I also have a pet companion. I can provide in my documents that my attorney who's managing my finances is authorized to care for my pet, to spend my finances for my pet, or to transfer my pet for pet care to an organization or to a family member or something like that. You have to be intentional if you have a close relationship with your pet to make sure that you think through that when you're doing your power of attorney. You can say, spend some of my funds to provide for food, outline some routines that your pet likes, the type of vet care. Some people even include in a list of like caregivers, like the professionals that support the pet, so that the attorney knows where to look for support. This is important if you have somebody that does not have a pet themselves, so that they know how to. I might be good with money, but I might not be good with how to manage and look after your pet for you. So it's better if you give me instructions and you give me guidance on where to get support. Finally, make sure you share your wishes in a letter of wishes. So a letter of wishes is non-binding, it's not legal, it's not a legally enforceable document, but it expresses your wishes to the trustee, the person that you're giving funds to look after and manage for the benefit of your pet, as well as the caregiver. And in a letter of wishes, you can include things like the type of living environment you want for your pet, if you have more than one pet, that whether they should stay together, um, the daily routines that the pets have, if they have one, the favorite foods, medical needs, the vet and grooming contacts, as I was talking about, who is around to kind of help take care of the pets, and the toys and supplies that they need. You can include all of this in the letter of wishes, and it's a guidance to the caregiver as well as a trustee about what you expect and hope for your pet. Finally, I wanted to provide you a quick checklist of some things to look for when you're doing estate planning. You need to have at least a primary caregiver and at least an alternate. You want to decide on the type of funding, whether it's going to be a cash gift that's directly to the caregiver, and really a trust in the caregiver to be able to use it for the benefit of the pet, but they don't have any legal obligation to do so. You could create a pet fund that has rules around it that's complex that require tax filing and everything, or you could do both. You want to update your will to include pet-specific clauses that says, this is the person I'm naming as my pet, my caregiver. This is the fund I'm setting aside. All those things should show up in your will. You should update your power of attorney if you haven't done so to include pet care instructions, as well as the authority of your attorney to use funds that you have to support your pets. You should express your wishes in a letter of wishes. That's non-binding, but will give some guidance. In that letter, you could identify somebody for emergency care, and you have to make sure that your plan is up to date as our pets can come in and out of our lives as they grow older and die and things like that. And so we want to make sure that we keep our plan up to date. That's really all I have for you today. I'm happy to take any questions you might have. So our key takeaways: the law and your heart is not aligned. Coming back to the story I told you at the beginning, there's misalignment between how we feel about our pet family members and how the law looks at them. Estate planning can help you bridge that gap. But remember that pet trusts do not work in BC. But they are great practical alternatives that we can use. We just have to make sure we use them. Plan for incapacity, not just death. Talk to your chosen caregiver for your pet, and always consult a lawyer, because we are the best people and everybody loves us. I'll stop here and I'll take questions if you have them.
Perfect. Thanks, Raphael. Does anyone have any questions? Nick?
Yeah, I have some. Thank you. Thank you so much for this presentation. So does the pet fund does it become a legal entity when it's formed? And how do you manage what's proper assets, asset allocation, investment policy, all of those decisions? Because normally it's a corporation or an individual, but in the pet scenario, how is that taken into account?
Yeah, so the fund is not a separate entity. It would essentially, you would treat it as if it's a trust, right? So you would treat it as if it's a trust, because remember I told you you have to name a backup human to take the funds if the pet dies before the fund is depleted. So really, it's kind of a trust. For tax filing purposes, a trust is a separate entity. But for all legal purposes, a trust is just a relationship. It's a relationship between the person that created the will, the person that's managing the fund, and the ultimate beneficiaries of the pet. And you can set the rules, but legally, it's not an entity. It's just a relationship. Tax filing purposes, the CRA treats it as if it's an entity. In terms of investment of those funds, the trust, if I don't specify how you're supposed to invest them in the will, the Trustee Act of BC or whatever province you're in will apply, and it limits kind of how you invest them. So generally, you will notice that in a will that contains like a pet fund, there's broad investment powers. And they will say that the powers I've given to my trustee with respect to my estate applies to the fund. That's generally how you would deal with that issue. Sorry, and then you asked the third question. What is the fund component like makeup? Generally people, I encourage my clients to leave cash, but then the trustee has the legal responsibility to invest the cash, and they can invest the cash in any way they see fit, as long as it meets what the rules have set for taking care of the pets, paying for their bills, all those things. As long as you can meet those, generally, in my documents at least, I leave flexibility on where to park the investments. And I try to give broader investment range than just the Trustee Act.
Yeah. So if it's a parrot that lives 300 years, then you got to invest more aggressively because inflation will eat up the cash.
Well, remember the actual fund has to collapse after 21 years after death, so it won't last for that long.
Okay.
That's what I'm saying. We don't have the US version of the pet trust that can last for as long as, and in fact, I was tempted to include this in my presentation. I think it's the Leona Hemsley Trust, where the dog that she created her trust for, they've cloned that dog multiple times, right? Because the dog itself has died, right? And then uh, technically it's still the same dog, but it's not. There's a really interesting Netflix program on it. I can't remember the name of it, but if it's still on Netflix and you search, hopefully you'll find it. It's That's the reason why we don't do that in Canada. It's for that, it leads to absurd results when you name somebody that's not a human as the ultimate beneficiary of a trust. Any other questions? Hopefully I've answered your questions, but I'm happy to.
Thank you. Yeah.
No worries.
I have a question.
Yeah, go ahead, Tanya.
Um, how does this work? Because I'm alone in Canada, my family is in Germany. How does it work with have the trusted person in another country?
Oh, if you have a trust where like the other person's is in a separate country,
Mm.
that's my daily reality. So you can create a trust in Canada for what's called a non-resident beneficiary. Right? So the beneficiary of a trust does not have to live here. The trust can exist here, or you can even provide that the trust moves to where the person lives. It's really the language in the trust that is created in the will. I guess we're talking about will here. So in the will, that specifies where the trust has to live. The big rule about where a trust is resident is where the people that are managing the trust, and the legal term is the central management and control of the trust. So where do the people that are controlling the trust, where do they make decisions? Not even where they live. Where do they make decisions and control like the resources of the trust? You can easily turn that trust to a German trust, for example. If your family member was non-resident, you could move it over there by making the central management control resident where they are. It just means they have to pay taxes in Canada and move, but they can move.
And what is if the scenario is the way around? So they have to create it in their country.
Sorry, excuse me?
So if the scenario is the way around, so I live here,
Yeah.
and because this is for a friend she was asking, but she has a friend who lives in Spain at the moment, and
Yeah.
she said like, hey, if something happened, I would like you to care for my pets. So this she has to create it in Spain.
Yeah, so the pets are located in Spain. That's where you would create it, right? And remember, like you saw that on one of the slides, the will provide for payment of the transportation of the pets from one location to another. You could do that there too, right? So you create the trust in Spain, you create the will in Spain because that's where they're domiciled, and then you provide that they can move to Canada and the pets can move along with it.
Yep.
Having said that, there's nothing that says you can create a trust in Canada for the pets, but why are you going to do that if you don't live here, right? So I could create a trust. I live in BC. I could create a trust in Toronto, in Ontario. Doesn't really matter. It's a relationship. But why would I do that? Pay Canadian taxes, all those things, if I'm not here and the trust is not here. So generally, you do it where you are, and then you provide for flexibility for it to move to where the new caregiver is going to be.
Yeah.
Any other questions?
I think it's fantastic to have this organization like Richmond. You mentioned this in Richmond that takes care professionally rather
Yeah.
than asking somebody and then they change their mind and they get this health issues with some entity that just takes care of your wishes.
Yeah. No, it's a really great organization. And it's not unique, but it's the one that I've worked with, so that's why I picked that one. But it's really great that exists.
Definitely. Any other questions for Raphael? No? Okay.
Well, thanks everyone. My information is on the screen. Feel free to reach out if you have any questions. I'm happy to chat.